So we need to talk about some very important developments in the critical assault weapon and magazine ban challenges that are up for Supreme Court review. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is First Form. A lot of you guys know that First Form has amazing supplements, protein powder, energy drinks, pre-workout, all of that stuff. And if you're looking to maybe get a little bit healthier this year, if one of your New Year's resolutions is to get in the gym more and get a little bit healthier, I highly recommend First Form. They're pro-America, pro-Second Amendment. They support me and the channel here. So if you're interested, if you want to check out some of their products, you can click the links down below. And if you use my unique link and you order something $50 or more, you'll get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, we're going to be talking about some of the developments in a few of the cases which are currently challenging various state bans on so-called assault weapons, simply just their rifle bans, and then also their magazine bans and restrictions as well. There are 3 critical cases that are currently seeking Supreme Court review. Those are the Snope versus Brown case, the Ocean State Tactical case, and then also Gray versus Jennings. Recently, we discussed how the plaintiffs in the Gray versus Jennings case decided to file a notice to the Supreme Court, and they essentially waived their 14-day waiting period requirement that was required for their case to be distributed to Supreme Court conference for the Supreme Court to consider and then ultimately potentially grant review. Now, this was done in the hopes that it would eventually have the option to be joined by the Snope and Ocean State Tactical case. Essentially, what the Gray versus Jennings plaintiffs wanted is to waive the 14-day waiting period and get their case conference along with those 2 other cases. Well, the Supreme Court docket has now indicated that the Gray versus Jennings case has now been set for conference, and that is going to happen on January 10th. So the plaintiffs in the Gray versus Jennings case wanted the case to be conference on January 10th, and the Supreme Court has docketed it and has set it for that same exact date that they had requested, so it's going to conference on January 10th. However, as of right now, the Snope and Ocean State Tactical case remain still only in the reschedule phase. They have not had a new conference date that has been set, so we need to talk about what is happening with these critical challenges and what is going to happen potentially going forward. Now, for those not aware, the Snope case kind of is the biggest and most important of the 3 in my opinion, because it deals with a state's ban on so-called assault weapons, which was prior granted, vacated, and remanded by the Supreme Court after Bruin, and this case was ruled on by the 4th Circuit en banc panel, and it's a final merits decision. The 4th Circuit en banc panel in that decision used the incorrect type of analysis. They used the military use test, and the Snope case is once again seeking Supreme Court review of that incorrect decision. The Snope case was originally set for Supreme Court conference on December 13th, but now the court has preemptively rescheduled the Snope case. They have not yet set a new date for conference, but all indications were that all the cases here were targeting January 10th, and that they wanted it to kind of be a conglomerate of cases where it would be Snope, Ocean State Tactical, and then now also potentially Gray versus Jennings. With the Gray versus Jennings case being set for the January 10th conference now, there is a strong chance that that is actually going to happen and that these 2 other cases will now join it at that same date. Now, in the Ocean State Tactical case, the plaintiffs challenged the state of Rhode Island's magazine ban and also a lower court denial of a preliminary injunction. Now, this case, unlike Snope, is still in an interlocutory posture, but it does deal with magazines and the lower court's review and ultimately a denial of the preliminary injunction. And that preliminary injunction would have temporarily blocked the state of Rhode Island's ban. Now, the Gray versus Jennings case is a little bit different. It's a challenge to the state of Delaware's restrictions on rifles and magazines. Now, in that case, the district court denied a preliminary injunction, and that decision was appealed then up to the 3rd Circuit Court of Appeals. The 3rd Circuit, in their decision, sided with Delaware, but instead of looking at the constitutional arguments, the circuit court instead focused only on the preliminary injunction factors, and they found that the plaintiffs could not show that the bans here in question actually caused an irreparable injury. The 3rd Circuit found that some constitutional harms are irreparable, but it insisted that those precedents all fell within the exception to our rule, and they presumed that the First Amendment harms are irreparable, but they found that Second Amendment restrictions and Second Amendment harms are not necessarily irreparable, and they do not automatically qualify for the preliminary injunction standards. So in essence, they're treating the Second Amendment as a second-class right. That ruling by the 3rd Circuit is now up for review in the Supreme Court. So keep in mind the Delaware case is a little bit different. It still deals with rifle bans and magazine bans, but it primarily focuses on the preliminary injunction, standards and factors. And it deals with primarily whether or not a restriction on your right to have magazines and rifles is a per se irreparable harm. Now, currently, these 3 Second Amendment cases are trying to get Supreme Court review. They're trying to get conferenced in the Supreme Court, probably by the January 10th deadline. And the whole focus of this is to get them conferenced, to get them considered, and then potentially relisted as well before the end of January. Like I mentioned recently, the petitioners in the Delaware case filed a notice that they were waiving the 14-day waiting period, that they wanted this to be distributed for conference on January 10th, and the Supreme Court has granted that request and they have set it for conference on January 10th. With Gray versus Jennings being set for that January 10th date, that's a great sign for the other two cases to now also be set for that same date. Now, why are all these lawsuits targeting January 10th, and why do they want it by that date? That's because all of these cases want a conference before the end of this term. Then they wanted also to have an option to be relisted in the following weeks. Now, you may be asking yourself, why is the Supreme Court relisting a case so important? Isn't that a bad thing? Now, you wouldn't be necessarily wrong for thinking that because, of course, it sounds bad if you hear, a case has been relisted, but that is not the case. Usually, a relist, especially a single relist, is a very good sign. In fact, according to all the data from the Supreme Court's 2016 to 2020 terms, between 31% and 43% of petitions that were relisted at least once were eventually granted review. And between 66% and 75% of all cases that were granted cert and review by the Supreme Court were relisted at least once. So the fundamental truth has become that if a case is relisted at least once, it has a higher chance of being granted review by the Supreme Court. And also, according to the data, there's another truth that 2 relists is not necessarily better than 1. What the data shows is that if a case is relisted multiple times, the odds of it getting reviewed by the Supreme Court is actually lower. Usually, multiple relists shows that the case is actually going to be denied review and that a dissent is likely being written in that case. For example, in 2022, only 28% of all cases were granted review after 2 relists. And the percentage drops even more the more times that it's relisted. Now, that's not always the truth. That's not always, the case. It's, one of the general rules, but, there are exceptions. But the odds usually go down as a case is relisted more times. So where does this data and all these developments actually leave us in these cases? All 3 of these cases are trying to get distributed to the January 10th conference. One of them has already been set, and that is the Gray versus Jennings case. And that's a good sign because they requested that date and the Supreme Court gave that date to them. All these cases want the opportunity to be conferenced early and then have a subsequent relist at the next conference, and then hopefully in the order list in the following week they get a grant of review in at least one of these cases. Now, the first domino fell down with the Gray versus Jennings case being set for conference on January 10th. Now we will hope at least maybe sometime this week on the docket of one of these cases, Snope or Ocean State, we will see that it also is getting set for that same day, the January 10th conference. So in the coming days, what we're going to want to see is that these cases are being set for conference, by January 10th. We don't want to see it too far out because if they're pushing it beyond January, that means that they're just going to punt this issue for a while. They're not going to address it. And so we want to see it, be set for January 10th. I would like to see the bundle of all 3 of these cases go to conference at the same time, and then hopefully a relist, and then hopefully at least one of these cases, my preference being the Snope case, is granted review by the Supreme Court. Again, if we get multiple relists, that's not a great sign. There are exceptions that, there have been situations where multiple relists were granted review by the Supreme Court, but in general, we do not want to see multiple relists. So these cases are now entering a very critical stage. We need to keep our eyes on the docket and all these entries in the Snope and Ocean State tactical case, but the Gray versus Jennings case being set for January 10th, as the plaintiff requested, is a good sign. I suspect that soon we're going to get clarification on the other 2 cases because right now they're just sitting in the reschedule phase. They have not had a new conference set, and I hope that it is going to be January 10th. So as we get more information, as things develop, I will let you guys know. If you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you guys for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.